I'm Mayor Tommy Roberts. Welcome back to the Mayor's Table. My guest this morning is City Attorney Jennifer Breakell. Jennifer, welcome.
Thank you, Mayor.
This is the first time you've been on the Mayor's Table.
Yes, sir, it has.
Well, it's good to have you here. And
it's nice to be here.
our topic today is one that I think is going to be of interest to many people in San Juan County. It has to do with the City of Bloomfield's proposal to create its own electric utility. And the segment today is being done in response to an opinion editorial that was published a week ago on September 18th in the Farmington Daily Times. It was authored by the city manager of the City of Bloomfield, Eric Strahl. And in that article, Mr. Strahl takes the issues that are the subject of a lawsuit that the City of Bloomfield filed against the City of Farmington, has taken it to the court of public opinion. And in my opinion, Mr. Strahl has attempted to portray the City of Farmington as dealing in bad faith in the course of this litigation. And I want to address some of those foundational issues that have led to the filing of the lawsuit by the City of Bloomfield against the City of Farmington. And more specifically, I want to address some of the assertions and statements of purported fact that Mr. Strahl uses in his op-ed piece. In my opinion, many of those statements are misleading or the result of misinformation. And I think we're in no position now other than that we have to respond in kind so that we can get our view of this litigation out to our public and who should be concerned about it. So I want to kind of take a look at the legal aspects of this dispute and relying on you to give us your expert opinion as to those legal opinions. I bear in mind and fully recognize there are always two sides to the story. But we need to be sure that our viewers, our citizens, and our customers have the side of the story that is ours. Yes, and we certainly want to deal with any misrepresentations or misinformation that's being put out there by the other party to this lawsuit. So first of all, Jennifer, if you would, and as briefly as you can, describe what is the subject of this litigation.
The subject of this litigation, Mayor, is essentially, it dates back 60 years at this point, which goes back to Basin Power and Light, which resulted in a lawsuit which created the Culpeper Decree. And the basis of this lawsuit is in reference to the interpretation of the Culpeper Decree and what properties, if any, Bloomfield would be entitled to in reference to the electric utility system that the City of Farmington operates and has constructed within their boundaries.
And so the issue is what the Culpeper Decree gave to the City of Bloomfield as a right to, in the future, acquire the assets of the Farmington electric utility system that are located within the municipal boundaries of Bloomfield.
Correct.
That's about as simply as you can put it.
That's the whole entire lawsuit.
And so the very foundational issue in this lawsuit is what is the scope of that right?
Correct.
Now, the City of Farmington has never taken the position that the City of Bloomfield does not have a right granted to it pursuant to that lawsuit, has it?
No, we have never taken that position. We've always said they have a right based upon the Culpeper Decree, but we have a disagreement on what that right is.
And so it's the scope of that right. And it's our position that the Culpeper Decree is very clear as to what the scope of that right is. The Culpeper Decree refers to the property, and the property is defined as those assets that existed at the time the decree was entered. Is that a correct assessment?
Yes, Mr. Mayor, it is. The Culpeper Decree actually uses the language, those such properties. And our contention is that those such properties reference those properties that were in existence at the time Basin Power and Light was in existence and what existed in Bloomfield at that time, not the infrastructure Farmington has built and created since that time.
Okay, and so our position is very much opposite from the position of the City of Bloomfield, obviously. The City of Bloomfield asserts that its right is much broader than that. In fact, it's a right that extends into perpetuity, that they have the right at any time, now or in the future, to acquire whatever property that is an asset of the City of Farmington's electric utility system, so long as it is located within their municipal boundaries.
That is the argument they are making, Mr. Mayor. That is not the argument we agree with, nor is that the argument we think that is supported by the language in the Culpeper decree.
Correct. So this becomes a very powerful tool if that is the scope of their right. All they have to do is use the power of annexation to pull within their municipal boundaries assets that we have at great risk constructed to provide service to people in the outlying parts of our county. So they have the ability to pick and choose what assets they want to have that we currently own, and they're not restricted by time or geographic area as to when they would exercise that right. That's the essence of their claim.
That is the essence of their claim, yes.
Yeah. So now let's move on to some of the assertions that Mr. Strahl has made in his op-ed piece. He implies that a recent ruling by Judge Daleys in a local district court case has essentially verified their view of what the scope of their right is, that they have an unlimited right in perpetuity combined with the power of annexation to acquire whatever they want to acquire and to pay fair market value for it. In your interpretation of the judge's decision, is that what he decided?
No, it's not. The judge actually has not decided the scope issue at this point. It is actually an issue we're waiting to have a hearing on. The judge made a ruling on the motion to dismiss, which is an incredibly hard motion to win. We lost that motion to dismiss, and the judge ruled that we did not have enough to win the motion to dismiss, but refrained from making any decisions based upon the scope or any other issues that are outstanding in the lawsuit.
So to be sure that our viewers understand what that motion to dismiss covered, we simply took the position that whatever right Bloomfield had under the Culpeper decree they had lost the right to assert it by waiting too long.
Correct.
We argued a statute of limitations defense, which is simply that parties to a potential dispute must bring their claims in a timely manner. And in this case, we asserted that Bloomfield, the city of Bloomfield, had sat on this right for too long, and that by sitting on the right for 60 years, they had lost it. The judge did not agree with us on that position, and he ruled in favor of Bloomfield. And so we're in a position now that we move forward in the lawsuit to determine the substantive scope of that right. And we get to that point in time where the judge is going to have to make a decision whether the city of Farmington is right in its view or the city of Bloomfield's right in its view that it has an unlimited right into perpetuity to acquire whatever it is we have in our system. So I think the next assertion that Mr. Strahl makes, he refers to another legal motion that we filed to split the lawsuit into two components. In other words, to bifurcate the trial on the substantive issues.
Yes, sir.
And the first issue that has to be resolved is the scope of Bloomfield's right. And then when the judge determines what that scope is and to what property or what assets of ours it applies to, then we have to follow through with the process of determining the value of those assets to which the right applies. And our motion is simply to, out of concern for judicial economy and
Yes.
costs and expenses to the parties, that it would be much more prudent to have the judge first rule on the scope of the right, and then once that is done, to determine what the value of those assets which are subject to that right. Now, Mr. Strahl says, and I'll quote him here, he says, "Now, in an effort to delay the process in hopes that Bloomfield will give up, Farmington filed yet another legal motion to split our lawsuit into two trials." What's your response to that?
It's a mischaracterization of the motion, and it's rather unfortunate, Mr. Mayor. The motion is a valid legal motion. It's actually the proper process to follow in reference to deciding what the scope of the properties are that Bloomfield is entitled to. it would be smart to determine that before you appraise an entire system that may not need to be praised, which will result in an excess amount of money being spent that may not necessarily need to be spent. And that's why Farmington has proposed to file this motion and is waiting for a hearing on it, because we feel like it is the best judicious use of resources.
Well, I think that most rational, reasonable people would understand that that is a reasonable approach to pursue, and that it ultimately would save the parties money. If there's no need for us to value our entire system that resides within the current municipal boundaries of Bloomfield, then that's an expense that we'd like to avoid. So we'll go a little bit more deeply into that issue here in a few moments. But I think it's interesting that Mr. Strahl thinks that the city of Farmington is really pursuing these legal strategies only to drag out the process in hopes that Bloomfield will get tired and that they can't stand up to the expense of pursuing the litigation that they filed in the first place. So I think it's important for our viewers to understand that once litigation is filed and once we believe we have an asset that's important for us to maintain and to operate, then yes, we're going to take the steps necessary that we think will help us prevail in that lawsuit. We'll talk more in the future about why it's important to the customers of the Farmington electric utility system that the city of Farmington take an aggressive approach in response to the city of Bloomfield's assertions that have manifested itself in the filing of this lawsuit. Absolutely. But as a final matter on the legal side of this dispute, Mr. Strahl essentially asserts that the city of Farmington has already completed its assessment of its resources and completed an evaluation of those assets, or at least he implies that the city of Farmington had indicated it was going to do that by the end of August of this year. Would you address that issue?
I sure will, Mr. Mayor. The city of Farmington has actually not commenced any appraisal on the Bloomfield system. We are actually still trying to establish what properties were in existence at the time Basin was in existence. We have entered a purchase order to acquire an appraiser should one be needed. In that purchase order, there was a start and end date as required by our system, but that was not an indication as to when the appraisal would occur. Bloomfield has assumed that's when the appraisal would occur, but there has never been a representation nor any information put forward by the city of Farmington saying our appraisal would be done by August. In fact, we have not even proceeded forward with our appraisal outside of forwarding some information to the appraiser.
Mr. Strahl has indicated that the city of Bloomfield is 95% complete with its evaluation of these assets. Do we know that that is a fact?
Well, Mr. Mayor, we have requested through several IPRA requests the information in that appraisal as it is public information. Bloomfield has refused to cooperate with that IPRA request and has said that it is not complete yet, even though they have been saying for months that it is almost 95% complete. So we do not have that information at this point, despite our numerous requests to acquire it.
So I think we need to be sure our viewers understand what an IPRA request is.
Yes, sir. So an IPRA request is the Inspection of Public Records Act. It's an act that all governmental entities fall underneath, and it allows citizens to have essentially open transparency to governmental actions. The appraisal that Bloomfield would be acquiring is paid for by public funds and would be subject to the Inspection of Public Records Act, and they should be handing it over. Unfortunately, we have not had access to that information yet.
And what is their reason for not responding to that IPRA request?
One of the reasons we have gotten is that the appraiser is declared as an expert, and therefore they are not sure if they're actually going to have that expert testify at trial, and therefore they don't have to hand over the documentation yet.
Okay. Well, Jennifer, I think this probably adequately covers the legal aspects that are raised in the course of Mr. Strahl's op-ed piece, and I think we've accomplished what I want to accomplish today in responding to what I would characterize as some misrepresentations about the essence of the legal proceeding. I appreciate your being here and helping me with this response. I would like to advise the viewers that next Monday, we will have as our guest City Manager Rob Mays. And Rob is going to talk about the more practical aspects of the dispute between the City of Bloomfield and the City of Farmington regarding Bloomfield's desire to create its own electrical utility. Rob will go into some detail about the revenue component of Bloomfield's pro forma, the fiscal pro forma, talk about the rate structure that we think that would be proposed, and we'll talk about the risk involved as well. We'll talk generally about why the customers of the Farmington Electric Utility System should be concerned about the proposal that Bloomfield has put forth and is pursuing. We think that there are some dramatic impacts that would be of concern to all of our customers on the Farmington Electric Utility System, including those residents and business owners and industrial customers that reside in Bloomfield. So Jennifer, once again, thank you for being here, and I think this is going to be very educational and informative to our viewers. We want to thank you for joining us on this segment of the Mayor's Table, and we'll look forward to seeing you again next Monday.